Waking things up this morning. Good morning, Illinois in Focus Daily. I'm Greg Bishop, back at it, live with you each and every weekday morning here with America's Talking Network and the Center Square. I'm the associate editor for Illinois, and that brings us here to Illinois in Focus Daily. Like, subscribe, hit that notification bell, wake up with us. People joining the chat room early this morning. Follow me anywhere, just search Bishop on Air. Got several segments we'll tackle today, two of them dealing with litigation against Illinois gun laws. Of course, the gun ban challenge that took place in the Southern District Federal Court last week, wrapping up on Thursday, a 4-day bench trial, and they've got 30 days to put together some final briefs before the judge issues a ruling in that case. But we'll also tackle the latest in the challenge against Illinois' prohibition of individuals with concealed carry permits being able to carry those firearms on public transit, and that case now being appealed to the 7th Circuit U.S. Court of Appeals. But we also got to take a look at what's going on up in Chicago with the contract for ShotSpotter expiring and some of the reaction from even city officials to that event. And Chicago Mayor Brandon Johnson putting out a statement yesterday about a request for proposal on that. So those are some of the things we're going to tackle this morning with Illinois in Focus Daily. I'm Greg Bishop. Thank you so much for being with us. Like, subscribe, hit that notification bell. Get the podcast anywhere you get podcasts. Just search Illinois in Focus Daily. Trial against Illinois' gun ban, likely touching on a variety of other things that could impact the outcome of other cases, including a case challenging the ban on silencers in Illinois. Good morning, Illinois in Focus Daily. I'm Greg Bishop, and the headline at thecentersquare.com. Gun ban trial touches on banned features plaintiffs say facilitate self-defense. So I wanted to go through this a bit because sitting in the courtroom last week, as the gun ban challenge wrapped up on Thursday, was pretty revealing in some of the testimony. And of course, you can check out my Twitter page, my X page, Bishop on Air, for all of that rough transcript. We're not going to get the transcript in the trial until sometime in December, but wanted to definitely get the info out via X so that people could review that going forward. But a lot of the trial, of course, as we talked about last week, focused on the difference between civilian firearms and military firearms, with experts kind of clashing as to whether semi-automatic only should be just for military, as well as, banning them from civilian use, with people coming at it from different approaches. But they also discussed a lot about features and the various features that are on these banned firearms. Everything from barrel shrouds to pistol grips to even flash suppressors. And the witnesses went into detail about what flash suppressors are used for, and in particular, they help move and direct the flash away from the individual's eyesight so that their eyesight's not blocked when they're firing in self-defense. That's what the plaintiff's witness said. But then the defense came back during some of the questioning and asked one of the plaintiff's witness, well, doesn't the flash suppressor also allow for an individual to better aim when they're in a dark movie theater? And that witness said, yeah, of course. But that question was posed to Dane Harrell. He is one of the lead plaintiffs in the consolidated cases, Harrell v. Raul. And he shared some of his thoughts on what exactly that question means and where that question comes from.
That may be true. An unlawful use for a firearm that's commonly used by law-abiding citizens for lawful purposes can be used in a way that's egregious, in a way that's illegal. But for a homeowner or for a business owner or a private citizen that's trying to protect their life or their family's lives or those around them, then obviously there's utility in a benign or in a favorable way as well.
So Harrell again talking about how it really goes to the intent of somebody's heart that's pulling the trigger. Saying that, people do it for lawful purposes to protect their homes, themselves, their family, their business. But when it comes to that flash suppressor being used for ill intent, again, he says that it comes to the intent of the individual behind the trigger. But they also discussed a variety of the other various attachments that are banned, including silencers. And Judge Stephen McGlynn, in questioning one of the plaintiff's witnesses, talked about how a suppressor, a silencer, with the threaded barrel of a handgun or even a rifle, allows for better hearing. Now, the plaintiff's witness in this case, Randy Watt, he had hearing problems, and he started off by talking about how his line of work has led to his hearing loss. And he talked about how, in his case, of course, the silencer really helps him continue practicing shooting for self-defense purposes and practicing and training, because it silences the fire. But, the other side, they may say that helps a criminal with ill intent to conduct criminal acts. But the silencer issue, with Judge Stephen McGlynn raising the question and explicitly saying, doesn't that help the others in a house be able to hear commands from the person who's approaching and confronting home invaders? And the witness said yes. But that really caught the attention of Mark Smith from Four Boxes Diner. He shared some of his thoughts of Judge McGlynn discussing the silencers and the use of these silencers and the common use test and so on.
He's connecting the dots between suppressors. He's talking about the Supreme Court precedent, and he's talking about the in common use test. Why is a judge connecting those dots with a single witness? Well, anything's possible. We can all speculate as to what he's doing. Maybe I'm totally wrong. But if it were me and I were a betting man, which I actually think I am, but set that issue aside, guess what? I'm betting that Judge McGlynn has connected the dots and realizes that indeed suppressors facilitate armed self-defense. Therefore, they're arms. Therefore, the text is satisfied. Therefore, the in common use test applies. Therefore, the government bears the burden to show that something's not in common use.
So the silencer was another attachment that was discussed in court, but also there were conversations about collapsible stocks, and the plaintiff saying the collapsible stock on the butt of a rifle helps ensure that anybody of any stature is able to operate that firearm safely. Pistol grips allows for the firearm operator to better aim. The barrel shroud allows for the firearm to have safety features. And so the plaintiffs really laid out all of these features were safety features for the individual who was firing the firearm. But of course, these various features are banned by state's law in Illinois, and that's what's being challenged. So clearly a lot of back and forth here, especially in the gun ban challenge. In the gun ban challenge, they have until October 21st to file remaining briefs before McGlynn issues an order. Now, the silencer ban, that was actually transferred, one of the cases, from Judge McGlynn to Judge David Dugan in the Southern District, and then it was consolidated with similar cases, and that case is now known as Morse versus Raul, and that case is still pending. Those consolidated cases and challenging the silencer ban in Illinois still pending. So clearly a lot more to be said about all of that here in the state of Illinois. Be sure to get the latest with Illinois in Focus Daily and the Center Square. Like, subscribe, hit that notification bell for America's Talking Network, and join us each and every weekday morning, giving you a rundown of things impacting the state of Illinois. We've got a lot to tackle, so be sure to stay with us each and every weekday morning here with America's Talking Network. state of Illinois appealing a judge's decision last month in federal court that the state's prohibition of individuals carrying concealed weapons on public transit is a violation of the Second Amendment. That appeal coming, at least the announcement of an appeal, on Friday. Good morning. It's a lot of back and forth with that case and the various filings. Then you get, throughout the year, more filings, the back and forth. They had an ultimate hearing on this, various status hearings. But last month, the order came out from the judge in this case, essentially denying the state's and the Cook County motion to dismiss the case and siding with the plaintiffs. So let's pull this up here. The memorandum, the order and opinion, as we see what the judge ultimately had to say in this, and pulling it up so that we can review this. But this is the order, and this was issued late last month, talking about the Illinois Firearms Concealed Carry Act, banning the carrying of firearms on public transit. And obviously a lot of back and forth and the precedent and the various arguments that were made. But ultimately the bottom line, let's get down to the conclusions here, where the judge lays it out as to what the outcome is of this case. And it says, as we get to the final remarks here, in the conclusive statements. Keep going. Here we are. So, final couple of pages here. This action's been properly brought before this court, despite the disputes over venue and standing. The parties can't escape the court. The parties also can't escape that this case requires navigating the murky waters of Bruin. That's the New York State Rifle and Pistol Association v. Bruin case out of New York. Plaintiffs' proposed conduct, carrying concealed handguns on public transit for self-defense, falls within the presumptive ambit of the Second Amendment, shifting the burden to the defendants to show that the Firearm Concealed Carry Act's ban falls within the historical tradition of firearm regulation in this country. On the record before the court in this case, defendants have failed to meet their burden. As for injunctive relief, plaintiffs have made no argument regarding why they're entitled to injunctive relief. Because they've forfeited the argument, they haven't established their entitlement to an injunction. The claims against Rick Amato and Eric Reinhart are dismissed without prejudice for lack of subject matter jurisdiction. Rick Amato and Eric Reinhart are terminated from the case. The remaining state defendants' motion for summary judgment is denied. Kim Fox's motion for summary judgment is denied. Plaintiff's motion for summary judgments granted in part. The court grants declaratory relief against Kwame Raoul, Kimberly Fox, and Robert Berlin in their official capacities, that the Firearm Concealed Carry Act's ban on carrying concealed firearms in public transit, as defined in the statute, violates the Second Amendment, as applied to Benjamin Schoenthal, carrying a concealed firearm for self-defense on Metra and on Metra's real property to the extent necessary to ride Metra. Again, that's pretty specific relief given to Schoenthal. The court grants declaratory relief against Kwame Raoul and Kimberly Fox in their official capacities that the Firearm Concealed Carry Act's ban on carrying concealed firearms in public transportation, as defined in the statute, violates the Second Amendment as applied to several other individuals that are wanting to ride Metra, CTA. So that's Mark Robolinski, Joseph Vessel, and Douglas Winston. Those, of course, are people who are getting relief on this, and that's all according to the federal district judge, Ian Johnson. So Johnson making that issue on August 30th. Governor J.B. Pritzker was asked about it shortly thereafter, a few days last month, and here's what he had to say in response to the federal judge, saying that the prohibition of carrying concealed firearms on public transit violates the Second Amendment.
Well, unfortunately, many of the conservative judges who've been appointed have misunderstood what it means to uphold public safety. And, we still believe in the Second Amendment. It's part of the Constitution, that you have rights as a result of the Second Amendment, but there are limitations to that. I mean, just to give one example, the right to bear arms, it's not the right to a shoulder-fired missile, as one example. There are limitations on the kinds of weapons and the places that we need to. Would we allow people to carry a an AR-15 into the White House? No. So it's clear that there are some misguided decisions that get made at the circuit court level, the federal court level, and I'm hoping that it'll be overturned along the way. If it has to go all the way to the Supreme Court, it'll be disappointing if they uphold this, but I'm hopeful that the law that was passed in Illinois a number of years ago that's frankly done a lot to keep people safe will be upheld.
So obviously he's saying that it's conservative federal judges that are making these decisions. I would imagine some people out there may point to Pritzker's involvement in the Illinois Supreme Court races and donating $1 million each to different Illinois Supreme Court justice candidates who ultimately did get elected and didn't recuse themselves in a couple of different cases. But regardless, interesting comments from the governor, and he was asked as well if he wants this to be appealed to the Seventh Circuit Court of Appeals.
That's not up to me. It's up to the Attorney General, although, we'll have to have some discussions about the best way forward in order to protect people as a result of that ruling.
And, of course, on Friday, they did indeed file that appeal, at least a notice of appeal. The Firearms Policy Coalition putting up that legal update saying that the public transportation carry ban filed ultimately an appeal in this. So late yesterday, they say, and this was on Saturday when they filed it on Friday. Late yesterday, the state filed a notice of appeal in our Schoenthal v. Raoul, Illinois public transportation carry ban lawsuit, asking for our victory to be reversed. Round 2 coming up. Stay tuned. So again, the notice of appeal says that defendants Kwame Raoul, Robert Berlin, Illinois officials sued in their official capacity, hereby appeal to the United States Court of Appeals for the Seventh Circuit from the order and final judgment dated August 30th, 2024. By this appeal, defendants respectfully request the reversal of the district court's order granting partial summary judgment to plaintiffs. So we'll track this in the Seventh Circuit U.S. Court of Appeals and where it exactly goes. But obviously, it's not the only gun case. We've been tracking the ban on semi-automatic firearms and magazines over certain capacities. We had that case wrap up the bench trial on summary judgment, final action in the district court on Thursday in the Southern District of Illinois. Before the case even started, Governor Pritzker was asked about that case as well, and if he has concerns in particular with Judge Stephen McGlynn in the Southern District having previously issued a preliminary injunction in this case. Does that signal that he's going to put in a permanent injunction in this case?
Well, as you know, my administration doesn't act as the attorney for the state. The Attorney General does. And I have a great deal of faith in our really great Attorney General, Kwame Raoul, who has defended the state in every one of these cases. But I'd make the same remark about that case as I would about the Rockford case, which is, there are misguided judges who are making decisions that I think are inappropriate and do not hold dear public safety the way that we do. And so I'm hopeful that that will get overturned at the decision will get made in mid-September the right way. But if it doesn't, that it'll get overturned by higher courts. Yes.
So again, Governor Pritzker saying that he believes that higher courts will ultimately reverse any outcome that goes against the state from the Southern District. But what about getting to the U.S. Supreme Courts in all of these cases? We'll be tracking it. All right, so be sure to like, subscribe, hit that notification bell for Illinois in Focus Daily as part of America's Talking Network right here on YouTube. stand by as we prepare for a live guest. This is Illinois in Focus Daily. Like, subscribe, hit that notification bell. Get this lined up here for you. Stay tuned. The contract Chicago has with ShotSpotter, a firearm sound detection technology, has expired, and Chicago Mayor Brandon Johnson saying he's putting out a request for information for, quote, reliable and efficient forms of first responder technology to ensure immediate attention in emergency situations. Welcome back. Illinois in Focus Daily. I'm Greg Bishop. Thanks for being with us each and every weekday morning. Be sure to like, subscribe, and hit that notification bell for America's Talking Network. What was it? Earlier this week, a Chicago Tribune reporter asked Mayor Johnson about the ShotSpotter technology. And here's that question that was asked and the mayor's response. Let's pull this up here. Get this on.
Helps with response. That's something that aldermen on both sides of today's vote talked about. Why isn't that already in place for September 23rd?
There's an entire process. It takes, relax, Jake, hold on. I promise you, I'm going to talk and then you can come right back. I promise you. Over the last several months, we've been working through a process. It's new. When this detection, put that in quotation, was put forth, guess what? There was no process. We're doing it differently. We are. And some things take time when you're doing it right. And we're going to do it right. Alders will get a chance to experience a brief, and there'll be a very robust opportunity for us to come to a conclusion.
What do you think is a reasonable timeline? It's already been, 7 months?
A reasonable timeline is to do it right. It's to do it right. I'm going to do it right.
Hi, Mayor.
Hey.
So again, that's
One
just
more question.
That's just some of the mayor's response to, quote, doing it right. But as he posted over the weekend here, he's got this brief statement on X saying the city has issued a request for information for reliable and efficient forms of first responder technology to ensure immediate attention in emergency situations. The use of acoustic gunshot detection technology from Sound Thinking Incorporated will end on Sunday, September 22nd, 2024. But other city officials, Silvana Tabaris, said that tonight's ShotSpotter decommission marks the implementation of the most radical, reckless, and dangerous policy in the history of our city. She says from the 23rd Ward, experts and community members all know that ShotSpotter provides a vital tool for first responders to render aid to victims of gun violence. Starting tonight, every gunshot victim left bleeding in the streets of our city will be a worthy sacrifice in the eyes of the mayor for his radical agenda. Every single one. Pretty powerful statements, but let's now shift over to William Kelly, who stands by to give us some of his thoughts on what's going on in Chicago. William, are you with us?
God bless you, Greg. How are you doing, brother?
You know, after a couple of weeks off, good to be back and to chat with you about what's going on here. So let's go ahead and get into it. Your response to the mayor essentially ending ShotSpotter.
Oof, it's like the narrow decree. It really is. As someone who was born and raised in Chicago, who loves Chicago with all of his heart, I'm not a Chicago basher. At any, the only time I ever cry or complain about Chicago is with tears in my eyes. The fact of the matter is, as you don't end one. It's like, I'm sure you were raised with the belief you don't quit a job until you have a new job waiting, right? Isn't that the middle class credo or something like that? Working class credo. Well, why in God's name would Brandon Johnson, mayor of Chicago, end one technology that the Chicago police, the CPD, say that they need, when he doesn't have anything to take its place, to replace it with, right? So, and we have double-digit shootings every weekend. This weekend it was low double digits, 30 shot. I guarantee you that if you're 33 shot, I think 6 fatalities. But that's only because yesterday there was a downpour of rain. I don't think rain is necessarily a reliable crime fighting technology. I suppose snow might be, but at any rate, it is heartbreaking. I was at City Hall for the last City Council meeting that I was shocked lasted. I didn't get out of that building until like 7 p.m. Because every single alderman and woman, older people, I guess is what they call them now, got up there and spoke, I thought, quite eloquently about the need for ShotSpotter, Greg.
Yeah, it's pretty incredible when you look at, again, the numbers of shooting victims, 33 shot, 6 killed, according to numbers that you've compiled. Obviously, what do you think is going to be in place of this? The mayor says he's putting out an RFI, request for information, on first responder technology. What other kinds of first responder technologies out there that could possibly compare to a service like ShotSpotter?
Well, the only technology, if you want to call it that I grew up having any faith in is something called criminal records. If somebody is a repeat violent offender, technically that might be somebody you might want to keep an eye on. But of course, nowadays that would be considered somehow a violation of criminal rights or something like this. What is the new technology? What is there's the real question is why would the mayor of Chicago discontinue this technology that's obviously working? Is it because he's just embarrassed that certain neighborhoods rack up 10,000, 20,000, 30,000 shooting gunshots with these on a regular basis? I'm talking about actual individual rounds being fired off. This technology actually counted the gunshots. Is it that he's just embarrassed that only certain neighborhoods rack up those kinds of gunshot statistics? I don't know. It is a genuine head scratcher, but sadly, and none of his explanations make any sense. He's saying that it costs, I think, $100 million or something like this for the ShotSpotter. Well, he's spending that much on culturally sensitive food for migrants, Greg.
We're talking with William Kelly, a reporter out of Chicago, an independent reporter, just recently getting his press credentials back after those press credentials were yanked by the former Chicago mayor, Lori Lightfoot, but now you got those back, and you had a moment to ask a question of the Chicago mayor, and it was more about kind of the political rhetoric, especially after what we know is the second attempted assassination of former President Donald Trump in just 2 months' time. I do want to air this for you. Not sure if you'll hear it, but I'll come back to you on the phone here after we watch this clip.
You mentioned Donald Trump. You brought his name up in the same sentence as shootings. Do you want to apologize or rescind any of your comments about Donald Trump that perhaps are actually motivating and inspiring people to go out and try to shoot Donald Trump?
Well, political violence is horrific, and there's no place for it. Calling out the fact that Donald Trump doesn't believe in our values to build affordable homes and to respond to mental health crises, to actually work with Congress to come up with comprehensive immigration reform. Calling those things out is the responsibility of leadership. That's all we're doing. We disagree politically, but in no way do I condone political acts of violence. Violence in any form is deadly and wicked. And I hope that this country continues to recognize that there's no place for it. Thank you.
So again, the mayor saying that political violence has no place and hopes that the country recognizes that. You go on to try to ask other questions, and he's wrapping up his news conference there. But William, the video that people can find on your X account, just search William J. Kelly reporter, and you'll be able to find that. But your thoughts on his response to that, especially considering previous comments he's made.
Right. Well, that was a follow-up question, by the way. My original question was, why are you prioritizing migrants over public safety, spending that is. I'll be releasing that, my original question on X today at William J. Kelly. We have a $223 million budget shortfall in Chicago for this year, a $1 billion shortfall for next year. Mayor Johnson's first thing out of his mouth to address the budget was to freeze police hiring. Okay, this is at a time when the police are down 2,000 officers, 150 of which are assigned to Mayor Johnson's personal security detail, which is, I think, an all-time high. I think Mayor Daley, the original Mayor Richard J. Daley, had two security officers, one to drive a car, the other one to get a newspaper. It's like, what the heck's going on here, Greg? But this is the head scratcher. This is, what is the priority? Who's really in charge here? Who owns Brandon Johnson? Because clearly his priorities are not with the actual citizens of Chicago, Greg.
William Kelly, one final issue here. Definitely want to get your thoughts on, as there seems to be some palace intrigue around who's going to head Chicago Public Schools, with Johnson asking the leader of CPS to step down. What's going on there, especially here as the school year just started up?
Yes, well, and there you go. I mean, thank you, Greg. God bless you. You're on it. You would think that if nothing else, the school children would be the mayor's priority. Both my parents were Chicago public school teachers. I can tell you it was a very different age, very different time. They cared about, teaching reading and writing and arithmetic, right? Well, that doesn't seem to be a priority of anyone at CPS anymore. It's all about the money for them. And apparently, Brandon Johnson is upset with Pedro Martinez, the CPS CEO, who is not keen on Johnson's idea to take out a $300 million loan to pay salary increases and pension costs to CPS employees. So, this seems to be the reason. It's all about the money. Surprise, surprise. Martinez, to his credit, who has a background, obviously, as a former chief, a financial officer, he, to his credit, is saying that this loan is, fiscally irresponsible, and it comes at too high of an interest rate. It could put the city as if there's any doubt, put the city in greater risk of future debt. So, I think, to go back to our original question, Johnson is really only interested in bringing more money to CPS, not even interested in the safety of our citizens when it comes to ShotSpotter, or even the education of the children at CPS schools. Greg, it really is heartbreaking.
Independent Chicago reporter William Kelly, greatly appreciate you taking the time on this Monday morning, and we'll definitely connect in the near future to get some more of your updates there from on the ground in Chicago. Be safe out there, all right?
God bless you. Thank you.
All right, it is Illinois in Focus Daily. I'm Greg Bishop here each and every weekday morning with you as we break down things important to you, the taxpayer in Illinois, and even up there in Chicago. Be sure to like, subscribe, hit that notification bell, and join us each and every weekday morning as we go live with Illinois in Focus Daily on America's Talking Network. Get the podcast anywhere you get podcasts. If you can't watch live, you can always revisit some of the segments again at America's Talking Network. We'll see you back here tomorrow for another edition of Illinois in Focus Daily.
So,